He is here today to talk about predicting the behavior of the Supreme Court. So if you would like to begin.
I would love to. And a remote, too. Well, thank you very much. It's a pleasure to be here at Rutgers and talk about something that's not political. It seems invariably when I go to Federalist chapters and talking about the travel ban or DACA or affirmative action, this is easy. So the topic today, which was billed as automated legal decision making, can be described a little bit more succinctly. How do we predict the behavior of the United States Supreme Court? Okay? How do we predict the behavior of the U.S. Supreme Court? Now, this idea of predicting what courts does is not new. If you think about it, everything you learn in law school is geared towards answering one question. What will a court, an agency, a tribunal do with my client's case? Over 100 years ago, in the common law, Oliver Wendell Holmes described it this way. The object of our study, then, is prediction. The prediction of the incidence of the public force through the instrumentality of the courts. And this is what all lawyers have to do. Now, historically, the way lawyers made predictions was based on their own knowledge. Well, I know this judge ruled a certain way in this case, and the facts here are similar, the facts are different. Here's what's going to happen. Okay. I'm not talking about that today. What I want to talk about is how technology can be used to predict the outcome of judicial decisions. And there have been many efforts at this, mostly at the Supreme Court. Going back to the 1970s, there was a famous study by Harold Spaeth, who predicted 91% of certain criminal procedure cases at the Supreme Court. Another paper in 1984 by Siegel discussing how to understand prediction. And then in 2004, a very famous paper called the Supreme Court Forecasting Project. It was the lead author was Ted Ruger, who's now the dean at UPenn. But then I came on the scene. And in 2012, I published a paper in the Northwestern Journal of Technology and IP about Fantasy SCOTUS, a Supreme Court fantasy league I made. And my most recent contribution, with my co-authors Michael Bomarito and Dan Katz, is predicting the behavior of the Supreme Court with an algorithm. That's what we're talking about today. So first off, Fantasy SCOTUS. Have you ever heard of it? Have you heard of it? None of you? Oh man, you guys are the outliers. In 2009, I created Fantasy SCOTUS as a fantasy Supreme Court of the United States. And I built it as a joke. I got a call from a reporter who said, this was back in 2009, said, Josh, what do you think the Supreme Court's going to do in the Citizens United case? It was a big case at the time. And I said, I don't know. I went to a friend. Wouldn't it be funny if Las Vegas took odds in the Supreme Court, right? You put a bet down, like fancy football for the Supreme Court. I'm like, wait a minute. No one built that. I'm going to build it. And I built it. And while still clerking, actually in Western Pennsylvania in Johnstown, I built Fantasy SCOTUS. It was a prediction market for the U.S. Supreme Court. And it was built on a concept known as the wisdom of the crowds. So for example, if I asked any one of you, what is the temperature in this room? I don't know, 71 degrees, 72 degrees, you'll give me a range, right? But if I ask everyone in the room the same question and then average it out, I will get almost the exact temperature, right? Why? As a general matter, when crowds aggregate, that is, combine their knowledge, they are more accurate than when one individual does it. It's a fact of life. I took a jar of jelly beans, and how many jelly beans are in this jar? And if I average together everyone in this room, that's probably the closest number I'm going to get, whereas it's better than asking one person. So when you have lots of people making predictions about the Supreme Court, it's going to be more accurate than one person making that prediction, even if the person is an expert. So today, I run Fantasy SCOTUS. It's in its 8th season, hard to believe, with a company called Lex Predict, which I'm a partner with. We have participation in law schools across the country, apparently not in Rutgers campus. Oh, there's no more Rutgers campus, just Rutgers. Okay, so I will, well, maybe it all bunches up in the Northeast corridor, but get on it, Rutgers. And the game is very simple, right? It's a game. How will each justice vote in a given case? Will they vote to affirm, or will they vote to reverse? And often it gets more complicated if there are multiple issues, if there's a plurality. But for most cases, this works pretty well. Is there an affirm or reverse the lower court decision. Fancy scores have been featured in the Times, the Journal, CNN, ABA Journal, virtually every major publication. And they usually call me when, at the end of June, right, where the big case is coming down. It's like, Josh, what's going to happen, right? How is the court going to decide this? And invariably, I'm like, well, let me tell you what the fans say. And I don't know. Let me tell you what the numbers say. And this is reviewed in the MIT Technology Review, in Science Magazine, and everywhere else. So you can log on today, and you can see for any given case what our predictions are. And we've had some pretty important predictions. So a couple years ago, we had the healthcare cases, the Obamacare decisions. And we actually ran predictions throughout the entirety of the Supreme Court's term of what people think would happen. And a remarkable aspect of this is how the oral arguments affect the predictions. We actually draw a line from both before and after the arguments were held. And we find that a lot of people can make much more accurate predictions after listening to the arguments. Why? Because the questions that the justices ask invariably inform which way they're leaning. Believe it or not, quite a number of people actually got the Obamacare decision correctly. Now, not talking about Obamacare today, but I did write a book if you want to read about it, called Unprecedented. Several years later, there's another Obamacare case called King versus Burwell. This was not a constitutional challenge to the Affordable Care Act. It was a statutory challenge. And here, too, you can see there's a huge drop-off. This was on 538 between the oral arguments and so after the argument, it looked pretty good for the government, and indeed that is what ultimately prevailed. We always offer our predictions in real time for each justice, how each justice will vote, and whether likely to affirm or reverse. Red is reverse, green is affirm. Okay? But that's the crowd, right? That's looking at how people think cases will turn out. My colleagues and I have developed something even better than people. Well, they're not better, but it supplements people. So there are three types of predictions. You can rely on experts, you can rely on crowds, and you can rely on algorithms. And our approach leverages all three: experts, crowds, and algorithms. And this is the algorithm we built. We put together a sample size of every Supreme Court decision, over the last 2 centuries, from 1816 to 2015, from the Marshall Court all the way to the Roberts Court. There were over 28,000 cases decided, and almost 250,000 votes by the justices. And we wanted to do an experiment. Let's pretend Fancy SCOTUS wasn't built in 2009, right? Let's pretend it existed in 1816. And on the day McCulloch v. Maryland was decided, right? Gibbons v. Ogden, pick your case. If we ran our algorithm on that morning, what would we have predicted? The true measure of a test is not, can it predict the Roberts Court, or can it predict the Warren Court, or the Berger Court? Can it be generalized? Can it predict the entirety of the Supreme Court? And we found is, it could. Our algorithm, which I'll discuss, works consistently at a rate north of 70% throughout the entire history of the Republic. Justices at different times in different places. Okay? So our big test is over the last 6 decades, right? How have we performed? So we start with the Warren Court, then we go into the Berger Court, then we go into the Rehnquist Court. I got to my picture, we have a new one now. And with the Roberts Court with the addition of Justice Gorsuch. We haven't done Gorsuch yet, we'll have to tweak that over the summer perhaps. And we're looking at 32 justices, right? And these are justices from across the spectrum. People to the far left, like Justice Brennan or Justice Marshall. People to the far right, like Justice Scalia or Justice Thomas. And then we have our middle-of-the-road judges, Justice O'Connor, Justice Kennedy, Justice Powell, Justice Harlan, right? And we want to see, can we predict each of these justices? And again, they're appointed by 12 different presidents who are all looking for very different things. They have Trump now, 13 presidents, as it were. And we're looking at over 8,000, nearly 8,000 opinions. So what's the bottom line? We predicted nearly 70% of the cases accurately. And it's a remarkable number that throughout this entire stretch, 70% accuracy is pretty consistent. And I want to show you this graph. I know lawyers don't like numbers, but you can look at pictures, right? If you just draw one of these smooth lines, it's right around 70%. It goes up and down. Some years we're closer to 80%. Some years we're closer to 50%. What that teaches is the Supreme Court is not a consistent body. They fluctuate in how they are, and that some years they're more predictable, and some years are less predictable. I'm sure Professor Iyer will agree. Some years the court says, wow, I did not expect that end of the year, right? And some years like, yeah, that's about what I expected. You don't know in advance which it's going to be year. It's going to be, wow, it's a predictable year or a non-predictable year. The key to prediction is making a generalized model that hits all of them, right? And I'll give you an easy example. In recent years, the court reverses more often than not, right? There are lots of reversals. So you say, wait a minute, Josh, I don't need your damn algorithm. I can just pick reverse everything. I'm going to win. Well, maybe you'll win in year 1 and year 2, but you lose in year 3 because you don't know in advance, is this going to be a reversal year or an affirming year, right? If the lower court is facing to the left and the higher court's to the right, that's reversal. If there's a lower court to the right and higher court, then it's affirmance. So we actually are able to break it down also along the various splits, right? You might think that the 9-0 reverse is the most common, but it fluctuates. In some years, it doesn't happen a lot. The most rare one is a 9-0 affirm. The conventional wisdom is the court usually takes a case to reverse it. Not so. There actually are surprisingly, at times, large numbers of 9-0 affirms. So if you never guess 9-0 affirm, you might miss a lot of these easy, low-hanging fruits. And of course, we have our 5-4s, right? The 5-4 reverse and the 5-4 affirm. And if you just follow these smooth lines, you'll see our model more or less tracks the fluctuations in the 5-4 affirms and the 5-4 reverses. In other words, we beat what's called the null model, right? We beat they're always going to reverse. It's just not the case. Even more fun is our accuracy for individual justices, right? And we built something called a heat map. Josh, what the hell is a heat map, right? This is actually color-coded, so you don't need to know numbers, right? A heat map shows the accuracy of how predictable a justice is. Some justices are very predictable. Some justices are not very predictable. So I'll give you an easy breakdown, right? Over the last 60 years or so, the hardest justices to predict have been Frankfurter, Harlan, and Powell. These are more or less the judges in the middle, right? They're more moderate. And you can see their colors, right, are mostly consistent, right? There's not a wide range in their color. The colors are pretty consistent. Now let's go into Justice O'Connor and Justice Kennedy. There's also a nice range in their colors, where some years they're green and some years they're orange. That is, some years they're predictable and some years they're not. And Katie will attest, some years that Justice Kennedy says, what the hell is that? And it's like, oh yeah, that's Kennedy, right? So it passes the gut check, where you don't know in advance if this is going to be a Anthony Kennedy makes Josh happy year or an Anthony Kennedy makes Katie happier. We just don't know that in advance. So I think we have an equal number of those years, it seems. But then we look at someone who's at the polls, right? Justice Brennan, who is quite liberal. Justice Marshall, quite liberal. Justice Thomas, who's quite conservative to the right. And their numbers show that they're pretty damn predictable. There's not a lot of shift, right? There's not much orange there. It's pretty solidly green, 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 green. I can't, the light's not good, but trust me on this one. The colors are pretty solid, that they surprise you very rarely, right? It didn't happen. I was like, wow, Brennan surprised me with that vote. Marshall really surprised me with that vote. Like, Thomas, no, you know what you're going to get. One of the more powerful things we actually have, though, is how justices change over their career. Now, we all know Justice Stevens, now he's proposing to repeal the Second Amendment. I told you I get political for a minute, maybe. But he didn't start off that way. And when he was first appointed by President Ford, he was viewed as maybe conservative, maybe moderate. And you can actually see, oh, it's hard with his lighting, that he has a lot more orange here, and as he goes on, a little bit less orange. That means he became more predictable. So not only did he shift to the left over his career, but it became more predictable that you knew where he was going to wind up. The second data point that's worth studying is Justice Rehnquist versus Chief Justice Rehnquist. So President Nixon appointed Rehnquist to the Supreme Court in 1972, and then 14 years later, President Reagan elevated him to be Chief Justice of the United States. And what you actually find is that in the earlier years, Rehnquist was pretty predictably conservative. But then later, I see a lot of variations in orange and brown there, right? He actually became harder to predict after he became Chief Justice. And this is something which scholars have written, that Rehnquist actually moved a little bit to the center upon his ascension as chief. He wanted to keep the court in line. So you can actually use this historical data to pinpoint the ways in which the justices have changed their predictability. Now, how do we do this, right? What's the magic sauce, so to speak? It's something called extremely randomized trees. And I don't need to bog you down, but what this effectively means is we run different experiments. We say, well, if this factor and this factor come together, what happens, right? Imagine you're planting a tree. You put a seed in and use this type of fertilizer and that type of water. Okay, you get a really big tree. Then you use a different fertilizer and a different type of water, you get a little tree. Okay, then we go with the big tree, right? It's a trial and error. We build lots of different what are called trees. We see which one's most accurate, and then we use the accurate trees. And this is what's often called machine learning. And I said there's a sign in the hallways, will lawyers replace us? Well, we're getting there. Not quite. I will not bore you with the code, which if you want to talk about later, we can. But what I will discuss is the various factors. When you study a case for common law, you have your outline for class, and you maybe list the facts and the posture and the lower court decision and the holding, right? Your outline has different sections. Believe it or not, cases can be broken up by about 100 different variables, right? 100 different variables for every case. What do I mean by that? For example, easy. What lower court rendered the decision? Okay, that's easy to decide. What type of case is it? Is it a corporate law case? Is it a tort case? Is it a securities case? Right, there are all different codes. Who's the petitioner? That is, who's filing the cert petition? Who's the respondent? What state do they come from? It gets a little more complicated. Then you can ask yourself, well, what is the ideological direction of the lower court? Was it a liberal decision or was it a conservative decision? And you start building this profile. Believe it or not, and we recently had the passing of Judge Reinhardt. This is a good way to explain it. If you had a decision from the Ninth Circuit from Judge Reinhardt, there's a pretty good indication it's going to get reversed by the court. Not always, but it's a good marker. And what we're able to develop is a metric of what different factors matter the most. And what we actually found is that ideology was actually not the most important factor. It has a weight to it, but it's not the most important factor. Other factors consider what type of case is it, is there a circuit split, how long has this issue been percolating. So it's not purely the law as politics, and actually I've been pleasantly surprised by that outcome. There is some law to it, because most cases the court are 9-0 reverses. But when you do get to the sort of 5-4 issues, that's where ideology, unfortunately, does play a little big of a role. So what do we do with this, right? Well, for the last 8 years, I've run what I call the Fantasy SCOTUS Tournament. And this was inspired by great matches in history. For example, when Deep Blue, the IBM computer, played Garry Kasparov, who's not just a Twitter fiend, but when he played Garry Kasparov on chess some years ago. You may have also seen on Jeopardy, Watson, who was a computer that IBM built to compete on Jeopardy. And what you find with these computers is they're very good at doing what they know how to do, but when they're given something new, they often struggle. And even on the Jeopardy episode, when Alex Trebek asked some questions that were a little bit off the wall, you would have answers that were completely bizarre, that made no sense, and because they just didn't understand the question. So what we're trying to do at LexPredict is not replace lawyers, and this is what your flyer said the whole way, right? This is not about replacing lawyers. I don't think it's going to happen anytime soon. It's about combining the strengths of humans and the strengths of machines. It sounds very much like the Terminator, right? But it's true, right? The future of automated legal decision-making is making what we call hybrid or synergy, right? Putting it together. And we developed an algorithm which we call Marshall Plus, after a great Chief Justice. Not a fan of his, but it works for the logo. And what is Marshall Plus? It's leveraging, right? It's not man versus machine. This is not like Judgment Day where we're fighting with the machines to death. It's about man with machine, if you will, a divine spark. Because when we have fancy SCOTUS, we have two columns, right? We have what we call the crowd prediction, and we have the Marshall Plus algorithmic prediction, right? These are two different ways of making the same result. And if you notice, they usually match up. Green's affirm, red is reverse, red's reverse. But in some cases, they're different, right? And it's usually with this guy, Mr. Kennedy, right? So the trick is this. When the humans say Kennedy goes this way, and the machines go Kennedy goes that way, who's right? One of them's right, one of them's wrong. And if we study this over the course of years and years and years, you can begin to develop what kind of cases do people get better, and what kind of cases do machines get better. And what we find is that you only need a certain crowd of maybe 10, 20, 30 people that's actually adequate. But what's important is we beat experts. Right? If you combine our crowd with our algorithm, we beat the experts. Some years ago, Tom Goldstein, who runs the SCOTUS blog, made a mistake. He put online his predictions for the last 10 cases of the term. Okay. So I challenged him, not that he responded, but I said, okay, here are my predictions, and I beat him on almost every one. Right? He didn't do that ever again. The Supreme Court Forecasting Project, which I mentioned earlier, by Dean Ruger, they interviewed all these experts, right? And their experts had an accuracy rate below ours, right? So when you're able to combine crowds with algorithms, you actually can beat experts. Because experts only know what they know. And we all have limited knowledge. We're not ignorant. We know what we know. But when you have a wide range of people, think of the jar of the jelly beans, right? You get a more precise outcome. And when you can merge the crowd predictions effectively with the algorithm predictions, you are now at the peak, right? You can now show. And here are our results from, I think, last year. Our crowd prediction had an accuracy rate of nearly 73%. The algorithm was at 65%, right? And our expert crowd, like our best players, were at 76%. When you find a way to merge all these things together, you're in business. You've now found how to move forward with automated legal decision making. Okay, so now, does this mean you're all out of a job, right? Are you all going to be losing your job? Will Robot Esquire take over? I don't think so. I don't think it's happening anytime soon. In fact, the current technology only helps you with the U.S. Supreme Court. The next phase, of course, is the lower courts. This should come as no surprise to you. Most cases never make it to the Supreme Court. They handle, 70 cases a year, and the number seems to be dropping every year. The bulk of the cases you're going to litigate will be in the federal courts of appeals, the federal district courts, and even there's actually the Texas Supreme Court, the state courts. So we're actually moving ahead to try to develop ways of predicting lower court decisions. Now, how do you do that, right? Who's going to build a profile of a district court judge? We don't have the same amount of data as we do as about Justice Kennedy. But we actually do, in that lower court judges make lots of decisions. And they have a docket. And if you study the docket, you can make... So I'll give you an easy example, right? Some judges love cases to go away on motion to dismiss. Right? They don't want to deal with it. Other judges love discovery. Some judges like granting discovery motions, others don't. Some judges are more likely to grant the pretrial motion in limine, other judges aren't. By studying how a judge responds to certain behaviors, they develop a pattern. Some judges rule for plaintiffs more often. Some judges rule for the defendants more often. This is something that can be studied and analyzed. So the next phase, the next evolution of this process is to understand the lower court decisions. Now, where does this matter? Has anyone heard of litigation finance? All right, what's litigation finance? If I need a lawyer and I can't afford it, I usually do what's called a contingency, right? Where the lawyer says, all right, Josh, you don't pay my bills now, but if we win, I get a cut of whatever word you get. How do lawyers decide whether to take that? They're taking a risk, right? They're saying, well, I'm taking this case on contingency. Maybe it'll win, maybe it won't. But what if you have prediction, right? What if you had some system say, okay, Josh has a 75% chance of winning $5 million, right? I say this judge's verdicts. He usually has higher end verdicts. Let's go with it. You take that case. But what if you're the defendant? You say, oh, crap. Josh has a 75% chance of winning this case, and we might be on the hook for $5 million. Let's settle this out. Let's not go to court. So you see, companies are already using prediction technologies to assess risk. On the plaintiff side, is it worth taking this case to court? On the defendant side, maybe we should settle this out and not be on the hook for even more exposure, right? So this technology actually has the potential to change the way litigation works. If we're able to accurately predict how cases come out, litigants can make much smarter decisions. Now, there's something bizarre about this. I presented this at a conference for judges a couple years ago. And there was one judge, he was in a court of appeals, I won't say his name, was a little bit freaked out by this thing. Wait a minute, Josh, how are you going to know what I'm going to do, right? You don't know me, right? You don't know what I'm going to do. I'm like, well, you've been a judge for a certain number of years, and you have a pattern, and we can predict with some accuracy. He's like, well, maybe I'll do the opposite, right? So then you have this weird thing, right? Imagine this, where the algorithm says Judge X will rule for the plaintiff. It's screw it, rule for the defendant, right? It makes you uncomfortable, right? Because if we try to go back to Mr. Holmes, right, at the very beginning where I began my talk, and we think of judges as, neutral magistrates, merely applying the law, and then I can have this little app on my iPhone that says, you're going to rule against me, right? I want a removal, change of venue. Oh, by the way, that's a big one, right? If you know your judge is not going to rule, you can change venue. And that's a huge decision that people can make now with data. But if you say, look, my judge can rule against me, it makes things a little bit uncomfortable, okay? But there are upsides to this, right? There's some upsides and there are downsides. So what are the upsides? For one, a lot of inequities in the law exist because there's not enough judges to resolve them. And an easy example is parking disputes, right? If you get a ticket and you say, no, I paid the meter. Here, I have my, I have my receipt that I paid for the meter. You can go to traffic court and maybe wait in line for 3 hours and maybe you'll get your ticket rescinded. Or you can develop an app that will simply say, okay, he was here, he showed receipt, wipe it out. You can create an algorithm to develop that process. The flip side is, you don't know what's behind the doors, right? When you have code, and code is resolving disputes, there can be inequities built into it. And that's not a laughing matter. And the companies that develop these develop these algorithms may not have the same sort of transparency that you would want them to. Think of like Uber or these various companies that leak data all the time. So there is a distinct risk in allowing technology to have this important role in decision making. But let me tell you, in your careers, throughout your lives, you will see this happen. And I think you'll remember this talk 20 years from now. Thank you so much. My friend Professor Iyer will offer some comments, and I welcome your remarks. Thank you so much.
Thank you, Professor Blackman. So I too think it is a pleasure to get to comment on something that Professor Blackman has written that is not something on which we disagree, since ordinarily we're sort of on opposite ends of the ideological spectrum. I think many of you know me. For those of you who don't, I'm a professor here at the law school. I teach civil procedure, constitutional law, and a variety of anti-discrimination law classes. I should start with the full disclosure that I know absolutely nothing about prediction markets, technology, decision trees. So I have essentially nothing to say about the sort of what's behind the scenes in all this. In terms of the sort of what's in front of the scenes, what this gives us, I wanted to talk a little bit about my perspective on this as a lawyer, and then a little bit about this from my perspective as a legal historian, which is what I do as an academic. So as a lawyer, I completely agree with Josh that there are ways that this could be very useful to decision-making as a lawyer. Some obvious circumstances are whether to take a case, whether to appeal it, whether to settle it. However, as somebody who was in the business of bringing sort of long-shot legal cases as a lawyer, I was a public interest lawyer litigating in a context where there was not law very much in my favor. I also like to think that an important piece of what lawyers do is not just looking at the odds, but also adding their own value and recognizing that good arguments can, in fact, change the odds, right? I've argued cases in front of conservative judges that I was told are going to rule against me, and they found in my favor, right? And so I think that's an important piece of to keep in mind, and I think it's kind of got to be your attitude as a lawyer that you're going to bring that value added to the case and change the odds in your favor. I will say that my perceptions on this are also influenced by what I do now as a legal scholar. I do a lot of legal history, so I'm often looking backwards, digging around in the papers of the justices to figure out how did this case come out the way that it did. And we have pretty good records for the sort of modern era. There's a number of justices that have opened their papers, and so up until 1994, which is the sort of latest access that we have, you can usually get some sense of what were the arguments in conference, what were the evolution of the draft opinions, what letters did the justices send to each other, which can give you a sort of general overview of what happened in a case. And there are many cases that look like the predictable 70%, right, where the justices vote a particular way at conference, there is no substantive correspondence among them after conference, there's a decision written, and it comes down pretty much without any apparent sort of bumps in the road, and the people line up in the way you'd expect them to based on what they've written in the past or what their ideological orientation is. But of course, those aren't the interesting cases. The interesting cases are the ones where, in a 5-4 case, a justice switches sides midway through the deliberations, and the case comes down differently. Or where somebody doesn't like the rationale in the original opinion. So, a law clerk comes up with a new one that's not well thought through that then goes on as doctrine for the next, 40 years. Or the cases where the justices are so divided that they find an excuse to dismiss the case as improvidently granted because they can't figure out a proper way to resolve it. And of course, those cases are not just the most interesting, they're also cases that can have really big implications. So because my field is LGBT rights, I often think about, for example, Bowers versus Hardwick, where Justice Powell switches sides, and you have a generation of gay people who are told that they can be made criminals as a result of that switch. So there's lots of places where there is room for, making the predictable case unpredictable. And I think that's a lesson that you can take both as a lawyer and certainly one I've taken from history. So I definitely think these types of tools are valuable. I think, everybody wants to know what's going to happen at the Supreme Court, right? I don't know why we're always so urgent to know before the cases come down, but people are. And as a lawyer, there is an important part of your job that's looking at the odds and thinking about how that affects decision-making for your client. So I'll go ahead and finish up there and leave time for questions for Professor Blackman.
Thank you. Thank you. So, let me address the point that Professor Aya raises, which is a fair one. What do we teach law students, right, if all cases are predictable? Right? Let's say in 10 years we can develop this technology to be like 90% accurate. And at that point, why do you even need judges? Right? Is there something about human judging that we like? So some years ago, we had a confirmation hearing for Justice Sotomayor. And there was a big fuss about a speech she'd given that said judges should have empathy, right? Judges show empathy. This was a debate some years ago. Can you teach a machine to have empathy? And let's say you don't like the word empathy. Let's use a word we know more, like equity, right? Courts of equity have been sitting for hundreds of years. You have the common law courts that do law, and you have the courts of equity that do equity. How do you incorporate a sense of equity into technology, where equity comes from a life lived, experiences, interactions with humanity. So there is some of a dark side of all of this, which I'm very much cognizant of, and I don't want to be too rah-rah about this. I do recognize there are issues here, but this will impact how law students can learn about the law as this technology develops. With that, I'll go to questions. Yes, sir. What's your name?
Gabriel.
Gabriel, thank you.
So during your talk, I was going to say, how is this actually helpful to lawyers? But then you gave your answer about how it makes with the decision making. But I don't understand the actual background of the data. But is there a way to kind of merge with Professor Ayer's idea of the fact that it's the actual argument making is what makes us a lawyer? So can you learn anything from the data?
Yeah.
To not just show the condition, but which arguments?
Yeah. Good. Very good question. Thanks, Gabriel. So one of our evolutions on this is looking at briefs. And can we make an accurate prediction based on briefs? And this comes up in one specific way, right? Let's say you compare a judge's opinion to the plaintiff's brief and the defendant's brief. If the judge's opinion has more citations that are similar to the plaintiff's brief, that suggests that the court was more persuaded by the plaintiff's arguments, right? If the judge's opinion has more of the same sort of citations as the defendant's brief, that suggests the judge is persuaded by the defendant. We can do that at the Supreme Court. You can actually do linguistic analysis, see what sorts of argumentation is in petitioner brief and respondent brief that winds up in the Supreme Court decision. And once you figure out what sorts of arguments worked in the past, you can do it prospectively for the future. So we are looking very carefully at what sorts of briefs are effective. Now, I can do this in a very cheap way. Are briefs from better law firms, right, more prestigious law firms, are they more likely to be incorporated to the final opinion? The answer is generally yes. Not always. Some law firms are better than others. Now, does that mean the law firm's reputation is the reason why, or that they have better lawyers? I don't know. Katie, we can debate about that. But you have groups like the ACLU, right, and Cato and other groups which get themselves cited a lot. Is that an indication? The second angle is oral argument. This is a very tough nut to crack because we don't have transcripts of all courts, but we do have the transcripts of the Supreme Court. And you can actually look, how often does a justice ask a question of a given side? Generally, the side they ask more questions of, they vote against that side, right? Because if a justice is going to vote for side A, well, I don't need to ask this lawyer any question. Let me go grill the other guy. So you can be a combination of the briefs and the oral arguments. You said argumentation. You can actually develop a better profile of what will happen. And that's something you can do for the lower courts, because all the briefs are available online. Not all the courts post recordings of the transcripts, but some of them are starting to. And that's something we can study. But this is an area that's very ripe for research. Yes, ma'am.
Do you think this kind of technology would be particularly applicable or particularly accurate in certain areas of law?
Yeah, what we actually find, and Katie will probably agree with this, in technical areas of law like tax, bankruptcy, we're a lot more accurate. When you get to like abortion, guns, same-sex marriage, it drops. But in terms of business doesn't really care about the abortion, the gun cases. They care about, a patent jurisdictional issue, right? That's what can make billions of dollars for these companies. So this is why companies are actually okay with this. There's an ERISA dispute, right? We're pretty good with ERISA, right? I hate ERISA, but it's good. Insurance disputes, we can get those with some accuracy. So the business interests are actually far greater for the predictable stuff. Law professors like the far more bizarre 5-4 issue that we don't always know what's going to happen.
And follow-up comment.
Please.
Do you think that the government in particular will be using more of this sort of technology in different areas going forward? I was thinking of the backlog. Keep hearing about in the news of asylum cases. It's in how many hundreds of thousands?
Oh, so I alluded to this.
With the,
Yeah.
Potential equity or...
No, I alluded to this with the parking ticket thing, right? Because that's an easy one, right? Whether you pay to meter or not, that's a yes or no answer. But there's a good question of whether the due process of law will be complied with if you're using an algorithm to resolve a case. I think maybe the process that's due for a traffic ticket could comply with this. I don't know with an asylum case whether you could reduce it to something that would work with a computer. Even if you could, I think the litigants would be very unhappy with it. Because, yeah, Katie, I welcome.
Yeah, I just wanted to add, I mean, I'm not aware of algorithms being used in that context, but algorithms are already being used, for example, as you may know, in like bail determinations, whether or not grant bail, how much the bail is going to be. I think that the due process stakes get higher and higher when you get towards an ultimate decision as opposed to, you know, intermediate decisions.
And Katie brings up a good point in the context of bail, right? To have an algorithm setting bail is like, oh wow, that's more fair than a judge pulling a number out of his hat, right? But you don't know what's going on behind the hood, what's called a black box, right? How that number is being come up with, it's not known. This also comes up what's called predictive policing, which you probably have read about, where, well, it takes a few pieces. If the police know who people are through facial recognition technology, and they say, well, these people are in this area at a certain given time, and they probably shouldn't be here, let's go send a cop to pat them down, right? So it's a little bit better than stop and frisk, perhaps, with some science behind it, but it can look a lot like stop and frisk, where you're basically using no actual reasonable suspicion, but just saying, cop, ask some questions, and they'll be able to pat them down. So even if this is not in the final adjudicatory mode, law enforcement is using these sorts of predictive algorithms to try to ascertain when gun violence will happen. In fact, one second, you actually have technology to say if certain people are together, the likelihood of a crime being committed are increasing by X%. Yes, ma'am?
Do you think this would also affect the civilians? Do you think that they would use your algorithm?
Yeah.
Like for their proximate, if they lost their ground when you guys?
Well, yeah, so you raised two very good questions. So technology can be both a blessing and a curse for pro se litigants. I'll give you an easy example, right? LegalZoom. Everyone heard of LegalZoom, right? They advertise on TV all the time. Let's say you're poor and you need a will done. You go on LegalZoom, was it $50, $100, whatever it is, not much. Okay, great. So you're saying, awesome, I have my will. Okay, then you die. And then your will goes to probate, and it's a piece of crap, right? That it didn't accurately assess your interests, that perhaps family members didn't know about it, and it's held in litigation for a year. So was a pro se litigant helped by this legal technology? Yes, no. I mean, you can argue it. But the bigger question is, people who can't afford attorneys and turn to legal aid has limited resources. I think in the future we're going to see these sorts of algorithms provide much more ambitious representation than just helping with a will. They actually help you prepare a brief, because we can study what arguments and briefs work, while we can actually put together a pro se asylum petition. I mean, most asylum petitions are copied and pasted anyway. They're usually pretty similar. They're templates at this point, and you could automate a lot of it. Now, you asked about liabilities. Well, I'm not in this business. I'm actually very careful about this because there's something called the unauthorized practice of law, UPL, which you guys learn about in school. And LegalZoom goes very close to that line. A couple of states have been shut down. I've actually had conversations with some tech companies saying what you're doing is a practice of law. And I suspect at some point when lawyers feel their bottom line getting pinched, some of these data firms are going to get their butt sued. So I'm very careful. For years I've been complaining about this, but I'm very careful not to cross that line. Yes, Kate?
So first of all, one of the biggest things that makes it easy to predict how your case will come out is if you are per se, you are likely to lose.
Yeah.
So it's too routine for those people.
Yeah.
Also, just to follow up on Josh's point about how legal aid could use this, there's community legal services in Philadelphia. Actually, has somebody who came from a programming background and has programmed a sort of mass expungement program that allows them to, people who have expungable offenses, do it in a much, much more efficient way.
So it's not so much replacing the lawyer, but making the lawyer's jobs more efficient.
Yeah. I mean, think of it this way, right? You all have Lexus and Westlaw, right? Before that, you had books in a library. How much time are you saving by running a search rather than having to go to a library? So it makes your jobs more efficient. So that's one thing. It's not about replacing, you're not going anywhere, but you'll have to have different tools and learn how to use data tools like the expungement tool Katie mentioned. Yes, sir.
So, you mentioned that you're aware of the fact that when you put this out there and judges see that you made a prediction, they're going to have a certain response to that. It seems to me that every time just technology in general, every time a new technology comes out, people respond to it, people adapt to it. There's this, give and take where we're uncomfortable with it, and we're comfortable with it, and when we're comfortable with it, we respond differently. So I guess my question is, given that people respond to technology and that you'll have to respond to that. Is your goal to get to a point where you don't have to tweak the algorithms anymore, or is your goal to have people constantly working on this to take into account the fact that what you do to the system will affect the system?
Oh, I see. Yeah, that's a deep question. Let me answer it this way, right? Let's say an algorithm says, without any doubt, the judge should rule this way, right? And the judge looks at it and says, well, crap, I was going to rule the other way, but I want to be seen as being outside the mainstream. And if we get to a point where judges start modifying their rulings to comport with what they should be doing, that's a hard question. I often joke, one day Justice Kennedy wakes up, doesn't have any breakfast, like, let me check Massey's code, see if I'm going to rule today, right? What then? I don't have an answer for you. It's a very good question, but I'm fully cognizant that in our lifetimes these issues will be confronted, that if everyone says judge should do X and the judge's like, well, I think that's wrong, then the judge is looked at as a radical. Yes. Oh, I'm sorry. Number one, number two. Go for it. Yeah.
You talked a little bit about trying to expand this to state courts, which to me seems to pose one very huge problem, which is that most state judiciaries are elected. So then somehow you have to add in that variable of electorate behavior and how the judges are going to respond to what they perceive as electoral pressure.
Yes. Yes, you're right.
Yeah.
Yes.
How would you go about doing that? Would you have to create a new algorithm, or could you maybe modify the one you're currently
So, I mean, this is something that's already been studied in the context, for example, the death penalty. And Katie probably knows about this. With respect to state trial judges, in years where they're up for re-election, they're more likely to inflict a death penalty than otherwise, because they want to be seen as being tough on crime. So this is something that's already been studied in other contexts, right? That when a judge is responsive to electoral politics, that their rulings might be influenced by it. This might be an argument against elected judiciary altogether. There are different forms of how you elect them, but you could actually model that with a little bit more accuracy, right? Because judges in the federal system are insulated. We have no idea. Judges in the elect system, they have elections, and you can see what's in their campaign ads and the like. You could actually model that with even more precision. But we're not doing criminal. I think criminal is a different ballgame altogether because there are different burdens. But in civil, I think you could. Yeah.
I was going to ask, how is your system affected by a new judge?
Oh, good question.
To get your system
Good question. So we built our system to move quickly when a new judge is added. And the way we do this is we try to model a new judge based on an old judge. So for example, when Justice Kagan joined the court in 2009, 2010, she had a similar, what's called an ideological score. It was called the Siegel score to Justice Ginsburg. So we started off modeling her as if she were Justice Ginsburg, and then over a couple of years we fade her out as she develops her own profile. Gorsuch just joined last. We haven't done Gorsuch yet. We'll do it probably this year. It's pretty smooth. We maybe have a 1 or 2 year rough kink. The hardest year, though, was last year when Scalia was gone. An 8-member court doesn't work very well for a lot of reasons, and it totally screwed up our predictions. Like we more or less just wrote off last year. It was just a weird thing for a lot of cases that had to be re-argued, and they affirmed 4-4. It's like, all right, whatever. We don't know. But we usually move pretty quickly when a new judge is added in a normal course. Yeah.
Follow up on that, so do you incorporate that new judge's lower court opinions into the profile?
Only indirectly insofar as it affects what's called their ideology score. So Gorsuch came on with a higher ideology score, so we'd probably say it's more similar to Alito rather than like a Roberts, for example. Katie?
So I was curious, I've been thinking a lot about, there was predictions about the presidential election on 538, roughly at your level of accuracy, which I think many people misunderstood as percentage support.
Yes.
Right?
Yes.
So, my question sort of centers on, in any individualized case, how are we talking about a 30% possibility it'll come out the other way, which seems to me still rather a big possibility.
Yeah.
Or in individualized cases, I think this sort of goes to a question that was asked earlier, can you get closer, and if so, how close? Like, what's the highest level for an individualized case in which you would say you have access?
Yeah, good question, Katie. So, you saw with the last election, people don't understand statistics, right? When they say that Hillary Clinton has a 75% chance of being president, that doesn't mean she's going to be, that doesn't mean she has a 75% chance. It means we're 75% certain that this is what's going to happen, right? That's very similar to our numbers. We're like basically 70% certain we're going to be right, which is not 100%. And we can't be 100%. We've done some internal numbers. I think we can't get much closer than 80%. I think that's a human capacity limit. Like our best predictors, like we have this one guy, his name is Jacob. He's an actuary, he lives in Brooklyn. Never went to law school, he's a savant. And he gets about 82, 83% of cases right. We think that's basically the upper human limit. We don't think, he's like, he's superhuman. This guy never went to law school. He just read Lawrence Tribe's common law book cover to cover. It's like, okay, no common law. Beautiful mind, right? He just read the entire book. The guy's a genius. I really respect him too because he knows this stuff so well. Yeah, he played for like 7 or 8 years. He dropped off last year. I'm not happy about that, but he was very good. He's at about 82, 83% certainty. That's about as high as I don't think we go much higher than that. That's our upper threshold. Beyond that, I don't think we can go. Yeah.
Have you read listening to Left's book, Black Swan?
I did.
Yeah. So, talking about, I don't think we can go above that 80% mark. Is that like, I don't think we can ever get above the 80% mark, or I don't think we can get above the 80% mark unless something happens that I couldn't possibly predict and allows for better technology?
Well, look, if Justice Kennedy's replaced by Justice Pryor, I think I can get above 85%. No, I mean that. I mean, one of the variables is the court has historically been somewhat balanced in the middle. I suppose it's theoretically possible if the court gets tilted very far to the right. If President Trump gets 3 or 4 more nominations, then maybe we can go above 80%. I think maybe I hadn't thought about that, but yeah, if Trump gets 4 nominees with a black swan event and then the court changes, Katie's already crying.
Well, the black swan could also just be like a development in technology. Like, so maybe you have access to new data, maybe we get new data processing software.
Yeah, I think even if we incorporate the arguments and the briefs, I think we're still low 80s, maybe mid 80s. I don't know, but I think that's our ceiling. Look, if you go to Vegas, right, or Atlantic City, and I tell you have 70% odds, you're going to take that to the bank every day, right? You're gonna go. Like when I actually had a guy ask me about the New Jersey sports betting case, which you know about this term, and I was explaining to him, yeah, we have about 70% access. Wait a minute, I go to Vegas and I have 49% odds, and like people still burn money. So I'm giving you 70% odds. Those odds are pretty good. You should take those.
But I mean, I think what that points to, right, is that it's not just about the technology. There are actual people who are making the decisions,
Yeah.
right? And one limit of our ability to predict may be that people are not entirely predictable.
Well, the parts of us that we conceive of as not predictable tend to be the parts of us that are actually much more predictable than we like to realize. The general model is like, all people are like all like some, like no other person, and it'd be like all in the like some parts of us that we have difficulty seeing with like our thinky parts, as I like to call them. So if you get to a point where someone with their thinky parts realize how to calculate and factor in the all and some parts of how we respond to things and how we respond to things and so on and so forth, we could eventually, theoretically, factor that into an algorithm that is able to access that data much more reliably than we are able to access that data in real time.
All right, we're getting into Battlestar Galactica style on territory there. But any more questions?
Thank you all so much for sticking around. Appreciate it.